If they want, we can.
What is the harm in that? आपने क्या बताया था?
Extremely allergic causing होता है.
It is further pointed out that carrot grass bracket में gajar booty, which is also an alien invasive species, is extremely injurious to health.
But ecosystem.
But it's whatever. क्या law नहीं इसको कोई?
There is no legislation regarding alien invasive species.
But there is no legislation restriction on its planting, buying and selling.
Yes.
Full stop. तो ये तो आपका काम है मिनिस्ट्री का.
नहीं सर,
नहीं ये मिनिस्ट्री का काम है ना.
वैसे सर मिनिस्ट्री जो है ना कोई
मिनिस्ट्री ऑफ क्लाइमेट चेंज का काम नहीं तो फिर ये किसका काम है?
मिनिस्ट्री ज्यादा पॉलिसी, क्योंकि फॉरेस्ट्री डिवॉल्व सब्जेक्ट है प्रोविंसेस.
आपका है ना इंस्पेक्टर जनरल ऑफ फॉरेस्ट और मिनिस्ट्री ऑफ क्लाइमेट चेंज एंड एनवायरमेंटल कोऑर्डिनेशन.
जी सर.
तो इसमें
पॉलिसी गाइडेंस दे सकते हैं, लेकिन जो अदरवाइज प्रोविंशियल सब्जेक्ट है तो प्रोविंसेस ने अपने अपने लॉज बनाए.
उसमें है ये कैरेट ग्रास?
इसके अंदर नहीं है.
अच्छा, आपकी मिनिस्ट्री में सेक्रेटरी इज द हाईएस्ट. ट्री वॉल्यूम टेबल हैज बीन यूज्ड. यू आर नंबर 2.
सर उसके बाद एडिशनल सेक्रेटरी होते हैं, मैं तो फॉरेस्ट्री विंग को देखता हूँ.
अच्छा, स्टॉप. अकॉर्डिंगली it is the Ministry of Climate Change and Coordination, Environmental Coordination, should implement a policy with regard to these matters and circulate it amongst the provinces to enable them to enact legislation, appropriate legislation, if they so deem fit. The lead role to play करें ना, vision वाला role. Full stop. ये next लिखें. Since there is unanimity in the removal of the paper mulberry tree, the restraining order stopping further cutting of such trees from the park is withdrawn, subject to the experts, foresters, providing guidelines to the concerned staff of CDA, who will strictly follow the same. In removing the paper mulberry trees. Full stop. These guidelines, CDA should also consider the substitute plantation of the species as identified by experts, with a view to ensure that they are indigenous and less dependent on frequent watering. Experts, do you agree? Less dependent on frequent on
इसका अल्टरनेट अगर आप इजाजत दें मैं लैंग्वेज बता दूं. इनपुट्स, एक्सटर्नल इनपुट्स, इट्स वाटरिंग इज वन. ये फिर पेस्टिसाइड भी डालते हैं, फिर ये खादें भी डालनी पड़ती हैं इनको.
Watering and
other external
inputs, comma, such as
watering, fertilizer, pesticides,
such as pesticides and fertilizer. दूसरों को नहीं जरूरत होती है.
लोकल को तो नहीं जरूरत, वो तो अडेप्टेड है.
अच्छा, ठीक है. Okay. The experts have also suggested that CDA should, what did you suggest earlier?
ट्रेनिंग अपने स्टाफ की मैंडेटरी करें.
नहीं, कुछ आपने और बात की थी.
एलियन स्पीशीज की स्ट्रेटेजी बनाएं.
They should evolve a strategy.
Long term strategy.
A short, medium and long term strategy. In consultation with experts regarding regarding future plantation as well as removal of alien invasive, injurious alien invasive species. All right? ठीक है, ये आप करने के लिए तैयार हैं?
यकीनन सर, और ये जरूरी भी है.
ओके, इन्होंने कंफर्म कर दिया एक्सपर्ट्स ने कि
The expert says that most of the trees, almost 98-99% that were removed were paper mulberry trees. ऊपर कहीं लिख दीजिएगा तो आप you can breathe a sigh of relief. ठीक है
सर, आपका शुक्रिया.
एक्सपर्ट्स का शुक्रिया नहीं करें, मगर ये जो तरीकेकार है आपका बिल्कुल गलत है. अगर इन्हें कहा तरीकेकार जो आप सही नहीं कर रहे हो. अच्छा, एक और इशू भी रेज हुआ था कि उधर जो स्ट्रीम्स जा रही है ना, उनको आप ये जो नेचुरल स्ट्रीम्स हैं इनको आप लोग सुएज ड्रेन्स बना दिया है, उसमें कचरा भी जाता है और ये भी जाता है. तो इस पे भी आप स्ट्रेटेजी को डेवलप करें. तो इनकी राय मशवरे अगर लेना चाहें एक्सपर्ट से, आपको हमने 2 जबरदस्त एक्सपर्ट से दिए. ये पूरे वक्त आपके नहीं रहेंगे. इसमें ऊपर लिखिए, लेट अ मीटिंग बी कन्वीन्ड एट द कन्वीनियंस ऑफ द एक्सपर्ट फॉरेस्टर्स for the initial guidance to be provided to concerned CDO officials with regard to the removal of paper mulberry trees from the park. Okay. Do you want आप इनको जरा केस को पेंडिंग रखते हैं, नहीं तो फिर हमें पता चल जाए. हाँ, it would be appreciated if the expert foresters may time to time visit the park, and if they require transportation, the same will be provided by CDA to ensure that the park is that the matter is being undertaken properly. हो सकता है कोई और आपके सजेशंस हो विद रिगार्ड टू पार्क्स, वो भी आप बता दीजिए. ठीक है. टू कम अप आफ्टर 1 month कर दें. ये प्रोजेक्ट कब तक आप कंप्लीट कर लोगे?
ये सर, अब बाहर का मौसम है, अभी तो इस सारे को रिमूव करके फौरन प्लांटेशन करनी है, तो 1 महीना तो हमें हर सूरत चाहिए होगा.
फिक्स आफ्टर 2 months कर दें फिर?
सर 2 महीने मुनासिब होगा जी, ज्यादा अच्छा.
अच्छा, टू बी फिक्स्ड आफ्टर 2 months. चलें, थैंक यू एंड थैंक यू एक्सपर्ट्स.
एक मेरी तजवीज़ है सर, दोनों एक्सपर्ट्स के लिए रेम्यूनरेशन अगर सीडीए को अगर इस पे कोई ऑर्डर हो जाए, मेरा ख्याल है कि शायद इनके लिए, अदरवाइज इसको मैनेज करना, और ये एक कॉन्टिन्यूस प्रोसेस है, गाइडेंस रिक्वायर्ड होगी इसके लिए, और मुसलसल हम भी फिर इनसे दरख्वास्त भी कर सकेंगे कि हमें हमारी रहनुमाई कीजिए वक्तन फवक्तन.
हम यूँ लिख देते हैं, इन केस सीडीए वांट्स टू एंगेज द सर्विसेज ऑफ द एक्सपर्ट. शायद आप और भी एक्सपर्ट्स करना चाहे, हमें नहीं पता है. ठीक है
सर, थैंक यू.
बट अभी तो ये आपको इनिशियल तो इन्होंने दे वॉलंटियर्ड, बट इफ यू थिंक देयर एक्सपर्टीज इज यूजफुल, आई एम श्योर यू विल डू इट.
सर
ठीक है
जी सर.
चलिए, थैंक यू डॉक्टर्स.
थैंक यू सर. थैंक यू.
Supplementary list: Suo motu case 4 of 2021 along with suo motu 5 of 21, Constitution petition 27 of 2022 and Constitution petition 4 of 2024.
जी. Mr. Haider Waheed is not available. अच्छा, okay. Mr. Salahuddin Ahmed hasn't scared you away, has he?
So smile that loneliness, but the won't scare you.
जी. Can you just remind where we were yesterday, the day before?
My Lord, I had pointed out the two aspects to my petition. One is the habitual misuse of the PICA law by FIA.
You had mentioned the cognizable, non-cognizable offences.
Ji, sir.
Then your main point was the law is not bad, its application is wrong.
My lord, I made both contentions, that one, that the law is being misused, two, that a part of the law is also ultra vires.
Which is that part?
Ji. Whoever intentionally and publicly exhibits or displays or transmits any information through any information system which he knows to be false and intimidates or harms the reputation or privacy of a natural person shall be punished with imprisonment for a term which may extend to 3 years, or with fine which may extend to 1 million rupees, or with both. Now, my lord, as your lordship had also mentioned on the last date, the Islamabad High Court had actually struck down Section 20, the part of it that deals with injury to reputation. I have the, sir...
Is it reported judgment?
No, sir, I don't think it... But
is it in any of these paper books? ये पूरा judgment है?
No, sir. There are some other judgments which I'll be referring to. I thought this would be easier.
Which page?
Sir, the first page, sir. It was only a short order.
Can we read it?
Ji, sir. For reasons to be recorded later, petition...
Have the reasons come?
No, sir. I don't believe they have.
Achha. Okay.
For reasons to be recorded later, petitions are allowed, and it is declared and directed as follows. Freedom of expression is a fundamental right, and it reinforces all other rights guaranteed under the Constitution. Free speech protected under Article 19 and the right to receive information under Article 19A of the Constitution are essential for development, progress, and prosperity of a society, and suppression thereof is unconstitutional and contrary to democratic values. C. The criminalization of defamation, protection of individual reputations through arrest and imprisonment, and the resultant chilling effect violates the letter of the Constitution, and the invalidity thereof is beyond reasonable doubt. The Prevention of Electronic Crimes Amendment Ordinance 2022 was promulgated in derogation of the Constitution and the fundamental rights guaranteed thereunder, particularly Articles 9, 14, 19, and 19A. The jurisdictional preconditions were also not in existence. The Prevention of Electronic Crimes Amendment Ordinance 2022 and promulgation thereof is declared unconstitutional, invalid beyond reasonable doubt, and it is therefore struck down. The offence under Section 20 of the Prevention...
The whole ordinance has gone?
Sir, वो एक amending ordinance आई थी, वो strike out, down हो गई. उसके बाद एक एक्ट आया है सर.
अच्छा, okay.
जी sir. And then F, which is relevant.
That is not relevant.
जी sir.
Okay.
F though.
So the judgment has been implemented.
जी sir. And I don't believe that any, the learned Attorney General will correct me, but I don't believe any appeal against this judgment has been preferred.
No, but if the law has been amended, then...
नहीं sir. जो F अगर देखें, F वो original ही था.
Okay, let's read it.
जी. The offence under Section 20 of the Prevention of Electronic Crimes Act 2016, to the extent of the expression or harms the reputation, and the punishment thereof is unconstitutional, invalid beyond reasonable doubt, and is therefore struck down. Then proceedings against petitioners in connected petitions are consequently a nullity and are quashed, aggrieved complainants. Then, my lord, H, federal government is expected to review defamation laws and the Defamation Ordinance 2002 and thereafter propose appropriate legislation to Majlis-e-Shura for making its implementation effective.
I don't understand this. What does this mean?
My lord,
H. What does it mean?
My lord, as
what
far
precisely? I don't know what it means. It's very generalized.
Yes, sir.
अच्छा, चलें आगे पढ़ते हैं.
Sir. The Secretary, Ministry of Interior, Government of Pakistan shall probe into the conduct of officials of the cybercrime wing of FIA, which had led to widespread abuse of powers and the consequent grave violations of fundamental rights of the citizens. Court expects Secretary, Ministry of Interior will conclude the probe within 30 days from date of receiving a certified copy of this order.
For our purposes, the only relevant bit is F.
Jesus.
The rest is not relevant for our purpose.
Yes, sir.
Take.
But although it does note that FIA has been abusing its powers generally, that is the second aspect. I'll come to that later. Now,
or harms the reputation.
Jesus.
So you want the words. Now let's read section 20 again.
Jesus. Whoever intentionally and publicly exhibits or displays or transmits any information through any information system which he knows to be false and intimidates or harms the reputation or privacy of a natural person shall be punished.
So you just want or harms the reputation deleted.
My lord, and I would additionally urge that even the or privacy is too vague an expression to be permissible under the limited scope of the exceptions to Article 19. Your Lordship will appreciate.
Read Article 14.
Sorry?
Article 14.
Article, ji sir, dignity sir.
Privacy to wahan aata hai.
Ji sir. The dignity of man and subject to law, the privacy of home shall be inviolable. No person shall be subjected to torture. Now,
so why privacy you want to expose?
My lord, my submission is that Article 19 ka scheme ye hai कि the restrictions that you impose on the freedom of speech, first of all you have to define them through a law.
No, but Article 14 gives privacy of home.
Bilkul sir. So the question over here would be, is this offense relatable only to privacy of home? Because what it is applied to is that this is our private, if a journalist is reporting on some public official's conduct, he says this is my private affair, you have breached my privacy, and therefore the FIA should pick you up. That is the problem, sir.
You can't just throw out privacy. You can qualify it.
Yes, sir. Bilkul.
How would you qualify it?
What happens is, sir.
No, what happens? Chhode.
Ji.
Again, that's.
Case law.
You the best law you can misuse.
Ji.
So that's. We're going to. How would you like to qualify privacy?
My lord, the same way that if there is some particular kind of thing that they are looking to stop, that is,
can someone photograph you in your sitting room, washroom, or wherever? I would imagine you will say no.
Yes, sir.
So how would you attend to something like that then?
My lord, that is the function of the legislature. The reason is
that's not defamation; it's privacy.
Ji, sir. Ji,
sir. I'm just someone's taking pictures of you.
Yes, sir.
So there is no defamation here. Yes. It may be defamatory as well, but that's another aspect. But yes, generally, it's not. It's just a privacy issue.
It may be a breach of privacy issue. Now,
if you take out privacy completely, then people will be leaning over the wall and taking pictures of you, and they find that they can't do anything.
Yes, I appreciate your lordship's point. That has to be protected, and it is a permissible object under the exceptions to Article 19. What I'm saying is that if the law is vague, it can cover everything and nothing.
That's why I'm saying, can you suggest some qualifying words that we can then interpret Section 20 in that manner and restrict its scope? That's what we are asking you.
My lord, it would be, I mean, I could come up with some formulations right now, but there may be things I miss and it may be too broad or too narrow.
By all means, you can supplement them later. I'm not saying give an answer now and then, because when I put it to you that or harms the reputation, you're saying this is domain of defamation. If there's a thief, I call him a thief, I'm not defaming him. But of course, I'm harming his reputation. So, but then the burden will shift on you, and I can sue you for defamation or whoever the concerned person is. Point taken. When you, because the judgment of Justice Athar Manila does not talk about privacy.
No, it doesn't.
He left it out. You want to introduce something new now.
Yes.
So we are going to do that under 184(3).
Yes.
Zara sa soch le, kyunki like you said, it could have. Someone is taking pictures of your child. Would you want that?
That is,
even if the child is not in your home, would you, in a park, would you like someone taking pictures of your child?
No, sir.
So don't do it.
Bilkul.
You can complain and it may come to haunt you.
Sir, agar aap section 24D dekh lein, when they want, they specifically define it.
No, you do it. You define it.
Zara agar dekh lein, sir, section 24D.
24?
D.
B or D? B. It's a B, D to hai.
D. 24C and 24D.
No, that's an extreme case. Let's not go there. I'm talking about normal. Your child is playing football in a field or cricket or whatever. Would you want your child picture taken?
D covers that also, sir. Agar aap 24D cyber stalking wala jo hai, take a photograph or make a video of any person and distributes it or displays or distributes it without his consent.
मुझे तो नहीं मिल रहा ये.
24D sir.
Small d, sir.
24 A B D का. Okay, small B. अच्छा, okay.
जी sir.
मैं alphabet अच्छा, okay, fine. Okay.
Take a photograph or make a video of any person and displays or distributes it without his consent in a manner that harms a person. Upar phir hai, watch or spy upon a person. C mein, watch or spy upon a person in a manner that results in fear of violence or serious alarm or distress in the mind of such person. Now, if
so you are saying that 24 attends to all privacy issues.
It attends to some of them. There may be other legitimate privacy interests, but in order to protect them, they have to actually formulate a specific law protecting a specific thing. If you just say that anything that breaches privacy is illegal and punishable with imprisonment, that is an overbroad, overgeneral curb on the freedom of speech. That falls afoul of Article 19 as per the case law developed on this subject.
Can you articulate something precisely on this? You don't have to do it now. You can file something on this privacy, keeping in mind what 24 hasn't already covered. So those kind of things, so we can come back to it. So can we move ahead?
Sir, bilkul. Sir, as far as Article 19 is concerned, as I was saying before your lordship, sir, that
in your petition you don't challenge this, or do you challenge?
My lord, I have pointed out that this the privacy aspect of it has not specifically been dealt with, sir. The privacy aspect of it, but Article 19 obviously has been reverted to, sir.
Again, there are two ways to do something. One is to strike down something.
Yes.
The other is to read down something. The third is to interpret something. Our interpretation also in a way becomes a law. So keep all these three aspects in mind, because I don't think we should do striking out, but maybe we can do the next two.
My lord.
Unless you can persuade us otherwise.
My lord, let me begin with Article 19, sir. Sir, उसमें तीन चीजें important hai. One is that the exceptions to freedom of speech is
reasonable.
One, that it has to be reasonable.
And
Number
imposed
two,
by law.
it has to be imposed by law. Number three, it has to meet one of the 7 objects mentioned in
I find 8, you find 7.
my lord,
Let's start counting them. Glory
of Islam, integrity, security or defense, I treat them as one, sir.
2.
2, friendly relations with foreign states. 3, public order.
4.
Decency or
5.
morality. 5.
No. Decency is different from morality.
Then it will be 8. So
Okay.
I treated decency and morality as part of the same, but then it will be 8.
I know there's common ground, but I think they're two different.
Sir.
And if the Constitution has used 2 different phrases,
Fair enough,
who are we to dilute there?
Fair enough, sir. Then in relation to contempt of court, and then this is important, sir, commission of or incitement to an offense.
I think this is the most important one.
Yes, sir. Because your lordship will appreciate that before the 4th constitutional amendment, this specifically included defamation. Defamation was omitted. Defamation was, instead of commission of, it used to be defamation or incitement to.
Defamation was there in the original Constitution.
Ji, sir.
And was removed by the 4th Amendment.
Ji, sir.
When was the 4th Amendment?
So that was 1975.
21st November 1975.
And removed
21 November 1975.
by 4th Amendment.
Ji, sir.
4th Amendment. 21 November
1975.
1975. Got
Now,
it.
incidentally,
What
sir,
was the reason for doing so?
my lord,
Did you see the whatever the debates or anything like that?
I have not been able to look at the debate, sir.
Okay.
But if I saw the 1956 Constitution.
Then I can think of reasons myself, but I was just wondering what had prevailed by the constitution makers to do so.
I've not been able to lay my hands on the debates yet, but it was there in all. Defamation was there in all the previous constitutions. It was there in the original 73 Constitution, but it was removed in this, in the 4th Amendment. Now, my submission is, sir, that the purpose of that removal is to decriminalize defamation. And that is the international trend, that defamation is in many countries, where they had criminal liability.
Mr. Salahuddin Ahmed, there's another case pending before this court, case of 2 very famous Pakistani singers, where one alleged sexual harassment against the other, and the other resorted to criminal defamation. And one of the questions posed in that is exactly what you're saying. ये है आपके पास रिपोर्टेड
Isha Shafiz and
नहीं वो
Ali
रिपोर्टेड
Zafar's,
है या उसका प्रिंट आउट दे दें नहीं उसमें मेरे ख्याल में एग्जैक्ट एक क्वेश्चन आया so we can leave it for that because it because ये है हमारे पास अच्छा चल I'll continue.
My lord, this is important actually, that case also, and I had advised at least one person who received an FIA notice in that case as well for expressing support for what Misha Shafi had said on Twitter or Facebook.
Let's not argue that case.
I'm not arguing it. I'm not arguing
let's
it.
not
What I'm saying is that Section 20 was applied in that case as well. Notices were sent by FIA on that ground as well. So what I'm saying is that the criminalization of defamatory speech, whether it be done through Section 20 of PICA or otherwise, that would itself fall afoul of the Article 19.
No, I was just thinking, shall we leave it for that? We're just trying to get the order and just see if it covers what you are going to say.
Sir.
Because it has not been decided. So I don't want to make that petition redundant. Because this very specific question was formulated therein. So can we proceed in the meantime, if they can just find it and give it to you?
Now, sir, even if a law is promulgated for the objects, the 8 objects mentioned in Article 19, even then it can only pass constitutional muster if they are reasonable.
Yes.
Now, the reasonableness.
ये इसकी एक और कॉपी दे दें. हाँ, मिल गया. It's 2022 SCMR 1267. सलाउद्दीन साहब को दीजिए. You can skip the factual aspects and you can turn to paragraph 4. Leave is granted to consider the following.
Whether Section 20 of PICA and any other provision thereof violate Article 19 of the Constitution, whether the defense of truth is undermined by Section 20 of PICA by criminalizing defamation, whether the criminalization of defamation negates, dilutes and or suppresses the fundamental right of freedom of speech and expression, whether, my lord, this would cover exactly
read on.
Whether an anomalous situation is created if both a civil case claiming damages on account of defamation and a criminal prosecution for defamation proceed and or to do so simultaneously, and whether this would undermine the fundamental right of a fair trial and due process enshrined in Article 10A of the Constitution, whether by invoking PICA against victims of sexual harassment and victims of other crimes amounts to silencing them and perpetuates injustice, whether Section 20 of PICA deters the wrong from accusing the wrongdoer and infringes the permission specifically granted to the wrong, that Allah does not like that evil should be uttered in public except by one who is wrong, Al-Quran, Surah Nisa 4 verse 148, whether the petitioners could have recourse to this court without having filed ICA, and then, my lord.
The other one, 2 technical ones. Does this, I think this is much more than what you're saying.
Yes, my lord.
Have we left out something?
No,
here?
this covers most of what I intended to argue before your lordship, which I made my submissions on.
So had you not read this order?
My lord, I had not seen this.
पहले कहते तो हम इसको भी लगा देते साथ में केस को.
Sir.
So I think इसको I don't want to, because it's a matter pending. Either we fix it with this one, but this is specifically to journalists, and that is not really specifically to journalists, but it's I'll tell you what the difference is. In a way, it will be on their rights. Here you are asserting journalistic rights. This case, on the contrary, is pushing journalism back. And these are my private rights, don't interfere. So, do you see what because privacy, paparazzi, and they chase people or take pictures from drones and stuff like that. So that may be contrary to what you are saying, because journalists will say, why can't I do so? And this is a pushback.
My lord.
So,
my lord, perhaps this aspect then, Article 19.
May we agree with Justice Athara Milla's judgment, that words, but privacy, since he did not touch upon and since the matter is already before this court in this other case, maybe we can just leave it aside, or alternatively, if you feel strongly, become a party in that petition and come there.
May I make a suggestion, sir?
Ji.
As far as my Article 19 challenge and Section 20 PICA challenge is concerned, that obviously covers common ground with that case, with Misha Shafi's case. That aspect can be heard when that file is called, or when that appeal is heard. The other aspect of this case regarding the abuse by FIA, which I was earlier talking about, were cognizable, non-cognizable. There are 3 or 4 other issues. Perhaps then I can go to those right now and reserve the part.
Okay. So I think we leave this one aside.
Okay.
But you are welcome to, if you now you know it, if you want to become a party.
My lord, I would obviously like this petition then to be heard. So
no. This petition pertains to journalists' rights. Like I said, this is an exception to journalistic rights. Because surely it's not the privacy of journalists you're talking about. It's invasion of privacy by journalists. It will be placed the other way around.
I see, in particular, the question number 3, whether criminalization of defamation negates the fundamental right of freedom of speech. That is what I'm arguing before your lordship. That is precisely the question.
उसमें हमने काफी wide रखा है चीजें को.
जी, और भी aspects हैं, but at least if your lordship is deciding that issue, then I would like to be heard.
ये हमें जरा सोचना होगा, उसको क्लब करें, क्या करें? Can you cover other ground?
जी, मैं other ground. Sir, on the last date I pointed out that Section 43 of PICA only recognized cyber terrorism, electronic propagation of sexually explicit material, and child pornography and related offense, child exploitation and related offenses to be cognizable. All the other offenses in the PICA law are non-cog. Now, the difference, there are 3 crucial differences, sir. As your lordship knows, one, that an FIR can't be registered in non-cog, that investigation can only be done if...
So the law is all right.
Yes.
It's misused. It's been misused or misapplied or intentionally, you're saying.
It has been done since 2016 when this law came. It was done in the Nawaz Sharif government, in the Imran Khan government, and now I'm here before your lordship again. Consistently, FIA has been using Section 20 as if it is allows it to carry out arrests.
One thing could be that you can educate FIA.
I don't think I'm capable, sir.
No, we can maybe appoint you, explain the English language, what is the intent of the law. I think it could be lack of education.
I don't think the problem is English, sir.
Hey, but at least you should not condemn somebody just like that. It could be.
Perhaps the learned Attorney General will explain when his turn comes. But sir, what I was pointing out is that 3 crucial differences which they ignore is: 1, they can't register an FIR; 2, they can't start investigation on their own. They have to wait for a magistrate to order. And number 3, they can't make arrests without permission. So far as journalists are concerned, if this free hand to FIA is checked, then many of our grievances will be redressed. Fine, we'll still have to go to the magistrate, etc. when a criminal complaint is filed.
Can you show us the notice which was actually sent?
जी बिल्कुल सर. ये है सर पेज
इसी में
मेरी पिटिशन में CP 4 में. If your lordship sees page 18. There are many notices sent to many different journalists. I'll just point out one notice. And sir, page 18 is a notice.
Can you read it?
Ji.
Forget the names, just read the content.
So the only important thing over here is the gist of allegations. The complainant is their own officer, so there's no private complainant.
Read the gist of allegations.
Explicit and malicious campaign against honorable judges of Supreme Court of Pakistan.
Continue reading.
Therefore, you are directed to appear before the undersigned to record your version at FIA Cybercrime Reporting Center on such and such date at such and such building, positively in interest of justice for fair trial process. In case of non-appearance, it will be assumed you have nothing to present or state in your defense.
This is a notice under 160 CRPC.
Ji, sir.
Let's read 160.
Any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself of any person being within limits of his own or any adjoining station, who, from the information given or otherwise, appears to be acquainted with the circumstances of the case, and such person shall attend as so required.
Has the law been violated?
Yes, sir.
How?
They had no power to investigate. There was no magistrate's order.
No, at the moment, no FIR has been registered.
Yes.
This is pre...
Sir,
I'm just trying to understand. It doesn't say after registration of an FIR.
Sir,
I mean, you may be called upon as a witness even.
Yes. Sir, investigation.
Again, let's go logically. Tomorrow I can receive a notice. Someone may mention me as a witness. It's not the case is against me. So I just want to, you can say it, this is a intent, they want to harass me, वो तो एक अलग बात है, but are they proceeding legally or not? ये हमें देखना है ना?
जी सर.
ठीक है, वो misuse वाली बात अलग होती है. वो आप किसी को भी, अब हो सकता है कोई कल कोई पता नहीं कोई केस हो, मुझे क्या पता, कोई बैंक में डाका हुआ था और वो खड़े थे सामने, मेरा नाम लिख दिया, तो पुलिस मुझे नोटिस दे देगी. ठीक है, तो ये उन्हें उस किस्म की नोटिस दिया, भी आपका केस तो कोई रजिस्टर नहीं है, मुझे पता नहीं कि किस लिए है.
Not someone
when I go there, I'll find out.
Someone is accused.
अभी उन्होंने आपको accused तो नहीं nominate किया ना. It's not you are FIR has been registered. Why are you assuming it? They may want to exonerate you, or they may want to harass you.
My lord.
Yes, sir. Attend to this.
Ji, sir. The way I understand it is that FIA has no power of investigation unless it relates to a cognizable offence. If an offence is
जी ये आपका कहीं नुकसान ना कर दे ये चीज मैं आपको बताऊं
जी
कभी कभी ऊपर से बहुत प्रेशर आता है ठीक है तो वो कुछ करने के लिए दिखाने के लिए कार्रवाई शायद वो भी अफसर समझता हो कि जी ये काम सही नहीं है सर हमने नोटिस दिया तो जरा सा प्रेशर भी उन्होंने डिफ्लेक्ट कर दिया आपको भी उन्होंने अरेस्ट नहीं किया और FIR भी नहीं काटी दे काइंड ऑफ I mean, let's live in the real world. Maybe this could be that. Maybe it's not that. Otherwise, they can just simply go and register an FIR, pick you up, arrest you.
My lord, they have not, except for one person, they didn't arrest anyone, actually. But this is exactly what the design was. You make an open-ended inquiry.
देखिए we can't strike down a legal action. If you can say it's an illegal action, we can strike it down. We cannot read what is in the mind of a person issuing the notice unless it is obvious. So if we make those precedents, then तो कभी genuine inquiries में वो कहेंगे जी ये Supreme Court का judgment है, आप हमें notice ही नहीं दे सकते.
जी sir.
They may just want you as a witness. They may want you in other capacity as well. They may, I don't know, whatever capacities there are.
Sir, let me try and explain myself, sir. The law is that if it is a cognizable offense, FIA or the police can investigate of its own accord. If it is not a cognizable offense, FIA cannot investigate, it cannot inquire, it cannot do anything.
You're missing the whole point. Read again section 160.
Ji, sir.
Read the title of section 160.
Power, police officers' power to require attendance of witnesses.
Witnesses?
Yes, sir.
It doesn't say accused,
sir,
or potential accused.
My lord, if we are dealing with practicalities, your lordship knows the section 160 notice goes, you appear before the office, then it is at the discretion of the FIA to keep you there or not.
I gave you an example where a officer who's under pressure is finding a solution to keep you also, to keep his, whoever is pushing him pacified, and at the same time not to harm you. We have to see all the scenarios. So they talk a middle way. Agar hum kehte hain ki ye notice de hi nahi sakte hain, so we are striking down section 160.
No, not at all. Then section 160 says any police officer making an investigation. How are you making an investigation when there is no FIR?
It says require attendance of witness.
Ji sir, आगे sir. Any
लेकिन that is also there. Naturally there will be some investigation.
Sir, वो तो title है ना, attendance of witness. उसके नीचे जो actual section है that says any police officer making an investigation under this chapter may require the attendance. How can you make an investigation when there is no FIR? Without an FIR, how? And you cannot have an FIR if it is not a cognizable offense. What happens is that on a non-cog offense,
do you know there's no FIR?
Sir, then they have to disclose it. That is the requirement. Yes.
Witness को disclose करने की
बिल्कुल है sir. Sir, 2012 SCMR.
SCMR से पहले कानून खत्म कर लेना.
जी sir.
We always run to SCMR. Sir. We just finish the law.
Sir, if your lordship will look at 154 and 155 also. In 154, that relates to cognizable offenses. Then 155 relates to non-cognizable offenses, and 155 too may be seen, sir. No police officer shall investigate a non-cognizable case without the order of a magistrate. Now, that is the crucial difference.
No, 1 second. When you issue a notice under section 160, do you have to say FI number so-and-so has been registered against so-and-so after obtaining permission of a magistrate, make all this disclosure, or can they just say, can you please come?
No, they can't say that, sir. The FIR is a predicate, and then when
I'm just saying the notice doesn't need to mention that.
Sir, the notice does. Has been defined by this court that you cannot give vague information to citizens and require them to appear at police stations. You have to tell them the offense. You have to tell them the details of the allegations.
But 160 doesn't say that.
My lord, that is the interpretation that has been taken by this court.
Now let's go to interpretation.
Ji, sir. Because
show us the interpretation.
Sir,
which citation?
Sir, ye PLD 2012. I'll just. PLD 2012, Supreme Court 903.
PLD 2012, 90?
903, sir.
ये section 160 पे?
जी sir. जो NAB, in the context of NAB.
No, just see, tell us 160.
Sir, NAB भी 160 का notice वो.
Where is that portion? Let's read that portion.
Sorry, sir.
Let's read that portion pertaining to section 160 notice. Because we are dealing with a notice that was issued to you under section 160.
If your lordship sees para 13. May I read, sir? 13 at page 914.
Ji.
The clear and unambiguous pronouncements given in the case titled Ghulam Hussain Baloch and others, PLA so-and-so, were violated by NAB in its 2 letters. In the cited precedent...
ये तो हमें नहीं पता ना, Section 160 का जिक्र कहाँ कर रहे हैं, ये बताएं.
Sir, the provision of the NAB law and the provision of Section 160 are pari materia. This is the same...
तो हमें कोई NAB law का कोई provision तो पढ़ देना.
जी सर.
तो लेटर्स की 2 बातें हो रही हैं, मम्मी पता नहीं क्या था उस लेटर में.
सर अगर मजीद पढ़ लें, it's the same thing. It's requiring attendance of witnesses. In the cited precedent, NAB has been given express guidelines as to its responsibilities while summoning or requiring attendance of persons, witnesses in an inquiry. As per ratio of the case, before summoning a person to attend, NAB was bound to identify and particularize the information sought from any witness, to state the nexus between such information and the subject of the inquiry being conducted by NAB. It was observed by the court that while calling for the information from any person, the person must be informed of the fact, point, allegation, offense, name of accused, specified matter, if any, concerning the matter in the notice, so that the person can furnish such information. None of this was done by NAB.
Show us the NAB ordinance.
Ji, sir.
Refer to the provisions of the NAB ordinance.
The chairman NAB, subsection 19.
मैंने पहले निकाल लिया था.
ये देखिए, ये बहुत स्पेशल लॉ है. ये तो चीजें दे रहा है, स्पेसिफाई कर रहा है, ये दो, वो दो, फलां दो. अब ये 160 CRPC वाला लॉ is not so detailed. Naturally, you make sense. It has to be regarding something. Fine, that point taken. But NAB, I don't think can you give a non-NAB case on this?
My lord,
because NAB case actually says that before you issuing a notice, because power to call for information, and it has a very detailed section which is completely different in its language from section 160.
My lord, the Islamabad High Court has followed...
Can you do a general law on criminal procedure, not a NAB law?
Ji, Islamabad High Court has followed it specifically for FIA also. It has applied this principle to FIA notices. ये page 5 है sir वो booklet की. The petitioner is a journalist. One of the most important functions of his occupation is reporting and informing the public.
Where are you reading from?
Sir, first page, sir.
Then he shows this. Yes.
Sir, page 7, 8 and 9. Para 3 से.
वो भी NAB को refer कर रही है. Yeah, I'm sure 160 has been interpreted otherwise. So this really doesn't help up. It's a circular argument. Don't you have any standalone case on 160?
My lord, I don't presently have one. I'll dig it out. But this was specifically to FIA notices. Now,
so it may well be, but they have applied the NAB provisions which are tailor-made for NAB. And this is a general law.
My lord, the scheme is...
If we start doing that, you may be empowering FIA with more things than they have. FIA will function under the normal law, not under the NAB law.
The FIA will function under the PICA and then
under its own
and
FIA
makes CRPC applicable.
सारे वो वाले लगेंगे ना?
जी सर, बिल्कुल.
तो आप ये उनको ज़्यादा इख्तियार मत दे दें फिर.
Sir, section 160 की, if your lordship sees the scheme. 160 CRPC की. Now, if a police officer, he is also a statutory functionary. If he is requiring my presence and if he is asking me some questions, he has to show that he has applied his mind. His notice to me must show that he has applied to his mind. If he is curtailing my liberty...
Now I'll place you in a very uncomfortable position. Can you for a minute become an officer of FIA and issue a notice under 160? Draft it. या तो क्या मैं कभी इशू ही नहीं करूंगा?
नहीं, बिल्कुल हो सकता है सर।
तो वो आप ड्राफ्ट करना है हमारी
सर, उसको उसमें आपने ये
आप जस्ट लिखें, यू जस्ट स्पेल इट आउट, यू मिस्टर ए, आप बताएं।
My lord, it would start out with FIR number so and so, name of accused number so and so, that the accused has been charged with offences under section 21.
No, you are saying that basically what you want is disclosure of an FIR. You want disclosure of an accused. That's the point.
Yes, and the information that I'm being sought with. Your lordship will appreciate that even asking me to go to a police station and record a statement, that is a curtailment of my liberty. Fine, the law allows for it. But if you are asking me to do it, then you give me the reasons why you are asking me to come to a police station. Otherwise, why should I go to any police station because some gentleman in FIA or some gentleman in...
Can't you be called pre-FIR?
No, sir.
Suppose, now there's a scenario. Someone goes and reports to the FIA. Say, जी ये सलाउद्दीन साहब के फोन में ये explicit pictures of children हैं, ठीक है? One thing is register an FIR against you. The one thing is FIA thing, पता नहीं ऐसी तो नहीं है, इसको कोई दुश्मनी तो नहीं है, चेक कर लेते हैं सलाउद्दीन साहब, इनको बुला लेते हैं. मतलब we should be very careful of your rights as well. They don't just think of journalists, because then वो होगा कि नहीं पहले FIR करो. So you have to go through the rigor of getting a bail before or a bail after, etc., where you may have a very good explanation, or it may be a total false, fictitious case, and FIR may throw it out without doing anything with it. We don't want to register FIR. But if you're going to force FIRs to be registered, I don't know, would you say कि किसने कहा, अच्छा उसने कहा, then you may have a, I don't know, very good explanation or no explanation. Then they may take the next step. ये power है उनके पास या नहीं है?
Difficulty.
Forget journalists for a minute. Just general law पे आ जाए ना.
Generally जो difficulty create है.
या वो अच्छा दूसरा example दे देते हैं. सलाउद्दीन अहमद ने मुझे कहा है कि तुम मुझे 1 करोड़ रुपए दो, नहीं तो मैं तुम्हारे बच्चे को अगवा कर लूंगा. And they think, nahi, you're not that kind of person, you won't do it. Let me check with you. So you say, no, first register an FIR against me. Let it be a false FIR. So what do I mean, like I'm saying, place yourself in an uncomfortable position of FIR for a minute.
The way it works, and there's a slight difference between FIA and the police over here, and I'll explain why. Of course, and the judgments of this court on it, that the police does not simply, because someone comes and relates some information, the police is not duty bound to immediately register an FIR.
But they want to ask you things. But they still want to ask you things.
It has to, it may want to check things, it may want to ask people things, etc.
How do they do it?
What I'm saying is...
No, I don't care what you're saying. How should they do it?
Not what the
because
police...
you drafted a notice, you wanted first FIR. Maybe they don't want to register, they don't want to check it out कि ये बात सही है गलत है, हम भी जरा थोड़ी बहुत तस्दीक कर लें अपने तौर पे. अब आपके घर आके नॉक करेंगे, आपको नोटिस भेजें, क्या करें वो आपके साथ?
My lord, they might come to my house and ask to talk to me without any compulsion.
आप कहोगे आपके पास वारंट है, मैं नहीं आता हूँ.
So then I will...
भाई आपको लीगली तरीके से डील कैसे करें वो?
होता यही है
यार, होता हमें पता है होता कैसे.
कानून भी यही है कि पुलिस जब तक FIR ना काटे तब तक किसी को कंपेल नहीं कर सकती. वॉलंटरीली अगर पुलिस मेरे घर पे आके मुझसे पूछे कि आपके फोन पे आप मुझे दिखाना चाहते हैं.
One question.
जी सर.
Section 160 of CRPC has to be applied and followed when there is Section 154, 155 or 150 already applied.
Yes, sir.
Because these sections are contained in Part 5.
Yes.
And Part 5 starts from Section 154.
Bilkul, sir.
Registration of FIR.
Sir.
Then 155, 160 cognizable, non-cognizable offences. And after that, comes into picture 160.
बिल्कुल सर,
Develop this argument.
मैं यही कहने की कोशिश कर रहा था सर कि अगर वो FIR
सलाउद्दीन साहब, थानों में तो 2 रजिस्टर होते हैं, एक FIR रजिस्टर कहलाता है और एक NC रजिस्टर भी कहलाता है.
And also remember section 157 sub 2.
Yes.
Where before registration of any FIR, the police is doubting the genuineness of the complaint and they may have inquiry.
आप हमें
Make out this case.
आप मुझे 157 का नोटिस
157 sub 2.
बिल्कुल
आप 160 पे बैठे हुए हैं आप. We want to take you elsewhere.
If from information received or otherwise an officer in charge of a police station has reason to suspect the commission of an offence which he is empowered under section 156 to investigate, he shall forthwith send a report of the same to a magistrate empowered to take cognizance of such offence upon a police report, and shall proceed in person or shall depute one of his subordinate officer not being below such rank as the provincial government may prescribe in this behalf, to proceed to the spot to investigate the facts and the circumstances of the case, and if necessary take measures for discovery and arrest of the offender.
Okay. अब ये आपको कहना चाहिए ना, ये वाली provision. Would you be okay if you received a notice and a 157, or that also they shouldn't issue you?
If, just asking. Yes, if an FIR is registered, they have every right.
FIR की बात नहीं होगी.
Sir, वो लिखा हुआ है ना sir. If your lordship sees, if the officer in charge of a police officer has reason to suspect.
आप पता नहीं कहाँ से पढ़ रहे, मेरा ये कुछ और पढ़ रहे, मेरे पास कुछ और है.
6 sir, 157.
157 पढ़िए.
कौन सा पढ़ रहे हैं?
If from information received or otherwise.
1% पढ़ रहे हैं ये. If from.
An officer in charge of a police station has reason to suspect the commission of an offence which he is empowered under 156 to investigate. 156 is cognizable offences.
Non-cognizable वाला बताए ना.
Sir, non-cog में तो वो ये काम कर ही नहीं सकता मैजिस्ट्रेट के ऑर्डर के बगैर. वो जी सर. Non-cog.
This is not your department, इसलिए हम आप.
Sir, non-cog तो 155
Let's read it.
जी sir. 157.
हाँ.
G. If from information received or otherwise an officer in charge of a police.
Where are you reading?
Sir, 157.
No, 155 पढ़ रहे ना. नहीं, non-cognizable पढ़ रहे ना.
Non-cognizable 155 है sir.
When information.
Where information is given, when information is given to an officer in charge of a police station of the commission within the limits of such station of a non-cognizable offence, he shall enter in a book to be kept as aforesaid the substance of such information and refer the informant to the magistrate. No police officer shall investigate a non-cognizable case without the order of a magistrate.
ये आपको आर्ग्यू करना चाहिए.
सर मैंने ये पढ़ा था सर पहले.
नहीं आप वो
I did read it.
नैप पे चले जा रहे.
I did read this earlier, sir. I'm sorry if I did not place enough emphasis on it, sir.
हाँ.
तो ये मेरा कहना है सर.
आप 3 भी पढ़ लें.
जी सर. Any police officer receiving such order may exercise the same powers in respect of the investigation except the power to arrest without warrant as an officer in charge of a police station.
So the protection is inbuilt in the law.
Yes, sir.
They should issue you a 155 notice.
Yes.
That they can do so provided the magistrate has permitted it.
Yes.
And
they can arrest me if
they can't arrest you.
If the magistrate gives the warrant.
वो warrant of arrest नहीं होगा.
बिल्कुल.
So अगर आपको ये कहना चाहिए जी अगर मुझे 155 की नोटिस भेज दें मुझे कोई इतराज नहीं है. 160 वाली नोटिस उस वक्त भेज सकते हैं जब FIR हो.
बिल्कुल.
और तो ये कहना कि पुलिस आप जा ही नहीं सकते हैं बुला ही नहीं सकते हैं वो गलत है. आपको कहना चाहिए 155 की मुझे नोटिस दें. जहां तक हमें समझ आ रही है बात.
और 155 का भी तभी होगा ना सर.
हाँ जब मैजिस्ट्रेट
जब
उसके तकाजे पूरे
and the reason why I am protected by that is that if I have genuinely maligned or defamed somebody and he goes to a magistrate.
हम ये भी तो नहीं चाहते कि धड़ाधड़ FIR लॉन्च करते रहें जब भी जरूरत ना हो. तो तो ये ऐसा भी पावर ना दें उनको, तो कभी कभी उनके भी जरा मसले होते हैं ना, जैसा आपको बताए, तो ये 155 की आपको नोटिस दे सकते हैं। ये बात हमारी सही है, ये इनकी कहना सही है? डू यू एग्री? यू आर ऑल्सो नॉट अ क्रिमिनल लॉयर।
क्या करें
आप क्रिमिनल काम करते हैं, आप
160 के तहत
आप सिविल करते हैं?
मतलब क्रिमिनल मैं करता हूँ, मतलब 160 जो है इंक्वायरी का है, क्रिमिनल प्रोसीडिंग इनिशिएट जब इन्वेस्टिगेशन में जाएगा फिर होंगी। अभी तो ये इंक्वायरी स्टेज पे है, इंक्वायरी पे तो किसी को भी बुलाया।
देखिए इनका बुनियादी छोटा सा, अब जो बात हमें समझ आ गई है, इनका कहना है ये दो किस्म के ऑफेंसेस हैं, एक है नॉन कॉग्निजेबल, एक है कॉग्निजेबल। ये जो अगर ऑफेंस बनता भी है तो ये बनेगा नॉन कॉग्निजेबल। नॉन कॉग्निजेबल से है कि आप मैजिस्ट्रेट और ये 155 का प्रोसीजर फॉलो करेंगे, रिपोर्ट लिखेंगे, मैजिस्ट्रेट से परमिशन लेंगे कि मैं इन साहब को बुलाना चाहता हूँ, फिर आप उसको नोटिस देंगे 155(2) का, उसमें उस नोटिस में भी आप उनको अरेस्ट नहीं कर सकते हैं अगर मैजिस्ट्रेट साहब ने वारंट ऑफ अरेस्ट ले लिया हो। 160 में खतरा इसलिए है क्योंकि अब आप जा रहे हैं कॉग्निजेबल ऑफेंसेस में, तो ये आप जैसे ही आप जाएंगे आपको अरेस्ट कर सकते हैं। ये फर्क आ गया है दोनों।
जो 155(2) है वो भी इन्वेस्टिगेशन से ट्रिगर होगा, इंक्वायरी पे नहीं होता। जरा ये रीड आउट कर लेते हैं।
नहीं, मगर वो परमिशन ले ली ना मैजिस्ट्रेट से, तो थोड़ा सा उसमें कुछ नजरसानी हो गई, एक हद तक प्राइमा फेसा है, हल्की फुल्की नजरसानी मैजिस्ट्रेट ने कर ली। हाँ चलो कर लो जाके,
खत्म हो जाती है
इंक्वायरी।
और फिर दूसरी बात यह है कि उसमें उसको खतरा नहीं कि मुझे अरेस्ट नहीं करेंगे, फिर उसको जाना होगा मैजिस्ट्रेट के पास जी मुझे वारंट ऑफ अरेस्ट भी दे दें, कहेगा हाँ जी आप जाके अरेस्ट कर लो। तो इसमें डबल प्रोटेक्शन है जो 160 में नहीं है।
160 के तहत तो अरेस्ट नहीं कर सकते जब तक ये कन्वर्टेड इन्वेस्टिगेशन में ना हो। इंक्वायरी के दौरान
तो फिर आपने 160 की नोटिस क्यों दी? आप 155 की नोटिस क्यों नहीं देते?
मैं आपसे सवाल पूछूं, इनका प्रोसीजर यही है क्योंकि हो सकता है ये आके कहें कि मैं वो पर्सन ही नहीं।
ये देखें, ये सीआरपीसी में प्रोसीजर ही लिखा हुआ है। तो 155 की आपने नोटिस इसलिए नहीं दी क्योंकि आप मैजिस्ट्रेट के पास नहीं गए
मालूम, और अभी इन्वेस्टिगेशन की स्टेज भी नहीं आई।
नहीं तो फिर ये फिर कह रहे आप मुझे ऐसी चाय पिलाने के लिए मत बुलाओ।
160 के तहत तो किसी को भी बुलाया जा सकता है, वो आके इनोसेंसी प्लीड करे।
फिर आप डिस्क्लोज करें ना, ये ऑफेंस है, ये एफआईआर नंबर है, आपको इसमें बुलाया जा रहा है। वो देखिए दो मुख्तलिफ तरीके कार है। एक सीरियस ऑफेंसेस जिसको कॉग्निजेबल कहते हैं, एक नॉन सीरियस ऑफेंसेस जिसको नॉन कॉग्निजेबल। ठीक है, कॉग्निजेबल में आप जो मर्जी करें, इनको अरेस्ट करें, एफआईआर करें, या अगर अरेस्ट नहीं करना चाहें 160 का नोटिस दे दें। ठीक है, नॉन कॉग्निजेबल में आपको मैजिस्ट्रेट से पहली दफा दस्तक देना होगी, फिर नोटिस देंगे, फिर दूसरी दफा दस्तक देना होगी अगर इनको आपको अरेस्ट करना है। तो दो अलग अलग चीजें हैं। या क्योंकि ये जब आपने कंसीड कर दिया कि ये आपने एफआईआर नहीं रजिस्टर की है, फिर आप ऑटोमेटिकली 160 का नोटिस दे ही नहीं सकते। फिर आपको 155 का नोटिस देंगे, वो भी मैजिस्ट्रेट के बाद, जहां तक हमें बात समझ आई है। अगर आप हमारी समझ गलत है, हमें
एफआईए का तरीकाकार डिफरेंट है।
जी,
एफआईए का तरीकाकार डिफरेंट है।
एफआईए का जो रूल्स है, सॉरी प्लीज नेवर से दिस, कानून में तरीकेकार, आप ये ना कि एफआईए का तरीकेकार डिफरेंस है, ये कोई चीज नहीं होती है कहने की। आप कानून में बता दें, या एफआईए के कानून में कोई ऐसी गुंजाइश है, बता दें हाँ जी ये शिक है, इसके तहत हम कर सकते हैं।
इंक्वायरी जब
नहीं, आप बताएं, ऐसे नहीं करें, हवा में नहीं करें, आप मुझे प्रिसाइज प्रोविजन बताएं।
हाँ है, देता हूँ एक सेकंड आपको।
आज हमारे सामने सिविल वकील फंस गए ना क्रिमिनल मैटर में। ये आप देख लीजिए, ये पॉइंट अगर आपके पास फौरन जवाब नहीं है।
तो ये एक्ट और रूल्स इसके बाद
फैसला है 1989 के इंक्वायरी विदाउट रिकॉर्डिंग एफआईआर।
ये पता नहीं क्या लिखा है। नहीं, वो कभी कभी तो वैसे बहुत से आ जाते हैं।
वेरिफिकेशन ऑफ कंप्लेंट माय लॉर्ड, सेक्शन 4 है इनका।
किसका, कौन सा कानून पढ़ रहे हैं?
एफआईए इन्वेस्टिगेशन एजेंसी इंक्वायरीज एंड इन्वेस्टिगेशन रूल्स 2002। मैं रूल 3 से माय लॉर्ड स्टार्ट करता हूँ। इनिशिएशन ऑफ एक्शन बाय एजेंसी, रूल 3 माय लॉर्ड, सब सेक्शन 1
जी।
The agency may subject to rule 4 and 5 initiate an inquiry.
दोबारा बताएं कौन सा सेक्शन है?
Rule 3 my lord.
हाँ,
The agency may subject to
ये तो नहीं है, कोई पता नहीं कहाँ से पढ़ रहे हो आप। Investigate FIA is a designated as an investigation agency.
ऑलरेडी इंक्वायरी इन्वेस्टिगेशन रूल्स 2002 है, रूल्स 2002।
अच्छा, ये FIA के रूल्स पर?
जी मालिक।
अच्छा जी
पढ़िए।
नहीं, वो पुराने रूल्स पर, वो 18 के
यार, वो तो FIA के रूल पढ़ लेना आप। हाँ ठीक है, हाँ पढ़े।
वही तो मैंने भी निकाला।
The agency may subject to rules 4 and 5 initiate an inquiry or an investigation either on its own initiative or on receipt of a complaint or oral or written information. After an inquiry or investigation has been registered, the inquiry of investigation shall proceed with care and discretion, and no undue publicity shall be given to it. Special care shall be taken to ensure that no unnecessary damage is caused to the prestige, reputation, and dignity of any public servant involved in the case. Rule 4, verification of complaints.
पढ़ते जाने, फायदा बताएं इसका रेलेवेंस क्या है?
ये जो रेलिवेंट है, 4 verification of complaints against public servants. The deputy director or an officer above the rank of deputy director may initiate verification of a complaint in order to ascertain the identity of the complainant or informer and genuineness of the complaint or information. No action shall be taken on any anonymous or
ये तो सूरत है जब FIA को कोई कंप्लेंट आएगी
माइलॉट, तब माइलॉट ये उन्होंने अपने तौर पर।
आप फिर इन सेक्शंस का हवाला दें, आप 160 का क्यों हवाला दे रहे हैं? अगर आप अपने रूल्स पे तहत चल रहे हैं, फिर आप अपने रूल्स का हवाला दें।
कंप्लेंट की वेरिफिकेशन के लिए जब ये बुलाते हैं तो 160 के तहत नोटिस देते हैं।
वकील साहब, आप मेन एक्ट का सेक्शन 5 भी पढ़ लें।
Powers of the members of the agency, my lord. Subject to any order which the federal government may make in this behalf, the members of the agency shall, for the purpose of an inquiry or investigation under this act, have throughout Pakistan such powers, including powers relating to search, arrest of person and seizure of property, and such duties, privilege and liabilities as the officer of a provincial police have in relation to the investigation of offence under the code or any other law for time being in force.
देखिए, सॉरी आप हमें प्रॉपर्ली गाइड नहीं कर रहे हैं, and I'll explain why. FIA is Federal Investigation Agency. They have got ample powers under different laws. पता नहीं इसके laws में आपको बता देता हूँ क्या क्या laws हैं. Electricity Act, Protection of Pakistan Act, Immigration Act, को पता नहीं 50-100 laws हैं. ठीक है. When you're dealing with a specific crime under a specific law, and that law provides for a particular methodology, you can then not use the general power of FIA. Then you have to use that law. जब आपने पीका का करना है कानून, हो सकता है आप दूसरे कानून में बगैर वारंट के अरेस्ट कर सकते हैं. जब आप पीका के तहत आप कोई चीज कर रहे हैं तो पीका की रिक्वायरमेंट्स आप पूरी करेंगे. ये तो नहीं कि आप एक जनरल अपना प्रोविजन डाल दिया उसमें. भाई 160 अप्लाई नहीं कर रहा है ना, आप बता रहे हैं अगर कॉग्निजेबल है तो फिर लिखें, इनकी बात सही है. अगर कॉग्निजेबल है तो फिर क्राइम नंबर बताएं, FIR नंबर सो एंड सो, ये सेक्शन है सो एंड सो, इसमें आपको तलब किया जा रहा है. नॉन कॉग्निजेबल है फिर जाइए मजिस्ट्रेट के पास. यू कैन पिक एंड चूज, यहाँ से जनरल लॉ उठा लिया, मगर जा रहा हूँ पर्टिकुलर लॉ में, उसका प्रोविजन इधर लगा दें. जब आप पर्टिकुलर लॉ में जाएंगे उसके फिर लवाजमात जो होंगे, जैसे इसलिए हमने इनको मना किया नैब का आप मत पढ़ें, नैब के अपने लवाजमात हैं. जी
माय लॉर्ड,
so we are dealing with a specific law, so you have to attend to that law.
My lord,
he is using the general ambit of FIA law.
Section 44 subsection 4 of PICA.
Section 4,
section 44 sir. Subsection 4.
ये मेरे ख्याल में किसी और ने ना करने हैं. आज जो दूसरे केस में काफी टाइम निकल गया.
It says that to the extent not inconsistent with this act, the procedure laid down under the code and the Qanun-e-Shahadat shall apply for the purpose of PICA. So it is the Code of Criminal Procedure.
But he's not referring to that. He's referring to a FIA Act.
No, sir. My lord is right. This is a special law. The process
because
provided
you have got many powers.
Yeah.
So when
there are several laws
a
which have to
particular
be
law, you
enforced.
follow, if it has a particular provisions, then you follow those. If you're doing this one, you follow those ones.
So if for example, this act was silent about what process will be followed for the purposes of
then you can go to the,
of course you can go to the court, but if this law is specifying, then you cannot. So to that extent,
आपकी अभी कोई immediate anxiety तो नहीं है ना?
My lord, anxiety है that the inquiries are pending. Under the FIA Act and the interpretation.
सलाउद्दीन साहब, कोई immediate anxiety है बता?
Sir, arrest.
क्योंकि ये तो इन्होंने आपके दो उड़ा दिए ना वो फाइल वाले।
सर
ये आपको कोई अरेस्ट नहीं कर रहे हैं, आप इनको कोई चलें इनका स्टेटमेंट लिख देते हैं, नहीं कर रहे हैं आपको अरेस्ट, ठीक है
सर?
हम इसको चलाएंगे, फिक्र ना करें, अब 2 बज गए।
I'm fine, sir.
आपकी अपनी सहूलियत की डेट भी दे देंगे, बता देना। And we don't want to rush through things which creates a bad precedent. We want to understand it properly so it has a lasting effect. And leave no loopholes in it either. So because you need to consider that other provision जो हमने आपसे बात की
वो मीशा शफी
नहीं, मीशा शफी का तो वो थे कि उसमें ऑलरेडी I don't want to, otherwise we'll have to issue them notice, फिर ये all अटक जाएगा. You can do it like that, we can club that with this one, but it may, I don't know if you want that. If we are dependent on the council there, they may not be available. फिर अजन होगा. So let's wrap it up. I want to wrap this up as fast as possible.
Sir.
But after giving you a full hearing.
Sir.
And the other matter is of this lady whose case has come between our meetings. वो क्या होता है? Committee की. तो हम आज के जुमेरात है, बुध है.
आज बुध है सर.
हो सकता है कल हम मीटिंग में इनका केस लगवा लें, देख लेंगे क्या है.
ठीक
नहीं है तो फिर आप ही इनकी बताइएगा, ठीक है? Please understand, powers of the Chief Justice have been diluted. किसी को ये बात समझ नहीं आ रही, मैं रोजाना ये बात बताना पड़ती है. आप पहले बस I am not all in all, now the committee is all in all.
True, sir.
So, unless I may not be happy, but that's how the lay of the land is. So when is it convenient?
I was just, my forlorn face was only if your lordship was adding to my burdens.
Which is?
Your lordship will appreciate 2 of the journalists.
Huh?
If your lordship was adding to my professional burdens, when your lordship says नहीं तो आप ही कर लीजिएगा, वो मुझे जरा.
नहीं, because her case is not before us, so that's how can we hear something which is not before?
Note, sir,
so वो क्योंकि that's also 184, that has to run through the committees. You know, I don't want to say all these things, procedural things. She won't understand these things. So I'm telling you कि भाई that has a procedure. If you adjourn it after Thursday, हो सकता है ये वो भी आ जाए केस में, अगर उनमें there's some new stuff she's saying. ठीक है, tell us a date of your convenience.
सर अब
आप किसके लिए है?
PFUJ और RIUJ की तरफ से
मौक़िफ़ अलग है जी. नहीं, मौक़िफ़ आप लोगों का एक है, सलाउद्दीन का या फर्क है?
एक ही है, इसमें हम कुछ चीजें ऐड करना चाहिए.
नहीं करेंगे, अभी तो इनको तो खत्म करने देना.
तो ये अब अगर ये कोर्ट में जमा करा दे
करें तो यहाँ नहीं जमा करें, वो जैसे जमा होती है जमा हो जाए.
एक बड़ा इम्पोर्टेंट
जी, प्लीज फाइल एनीथिंग यू वांट,
वो मैं कर देता हूँ. एक ये लॉर्डशिप बड़ा इम्पोर्टेंट एस्पेक्ट है, वो ये
बहस ना कीजिए ना
कि 2021 में एक लॉ बना था विच इज एन एक्ट ऑफ पार्लियामेंट, प्रोटेक्शन ऑफ जर्नलिस्ट्स एंड.
आपने क्या खूबसूरत बात की थी, एक लॉ बना था विच इज एन एक्ट ऑफ पार्लियामेंट.
सॉरी, जस्ट रोजा का भी असर हो सकता है. एक लॉ है जो प्रोटेक्शन फॉर जर्नलिस्ट एंड मीडिया प्रोफेशनल एक्ट 2021, ये बिल्कुल अभी इसको प्रॉपरली इम्प्लीमेंट नहीं किया गया.
इसमें ऐसी कोई बातें जो ये बात कर रहे हैं,
योर लॉर्डशिप बहुत सारी बातें.
ठीक है, फिर देखेंगे उसको.
ये बड़ा रेलेवेंट
नहीं, हम देखेंगे.
जी जी लॉर्डशिप,
अब की वक्त आएगा हम देख लेंगे ना, अभी तो हमारे सामने नहीं है ना. बिल्कुल खत्म करने दे, आपको भी सुनेंगे. आपको जल्दी में तो नहीं है? हाँ,
प्रॉपर.
ये तो कराची से आ रहे हैं, आप तो यही हैं.
नहीं लॉर्डशिप,
तो लेट अस हियर हिम एट हिज डेट ऑफ हिज कन्वीनियंस.
योर लॉर्डशिप,
व्हाट इज द डेट of your convenience?
Before Eid or after Eid?
Any date of your convenience. I mean, we can hear it tomorrow. No, except tomorrow. Any date of your convenience. Whatever you. I was tied up with some other case of yours.
Next Tuesday.
ठीक है. हाँ, ठीक है. And if you want earlier in the day, बता दीजिएगा. Just remind us. Sometimes we don't realize if you want to go back the same day.
Early in the day is fine, sir.
ठीक है, no. तो 2nd of April.
ठीक है. सर एक और रिक्वेस्ट थी. जी. Your Lordship has. सर वो पुलिस की वो रिपोर्ट आई थी in Matiullah Jan's and Absara.
हाँ. वो कुछ मजीद आपने फाइल किए रिपोर्ट्स? And
we have
unknown.
So the two cases in Absar Alam's case, the two people who are not in Pakistan, उनके red warrants के issue करने का process आपकी इन proceedings के बाद हुआ है. उससे पहले 1.5 साल में कुछ नहीं हुआ. So
क्या process हुआ?
The issuance of red warrants, blocking of their CNICs.
Red warrants through Interpol.
जी, Interpol.
Okay.
So that process has begun. The warrants were obtained and the process has been initiated. वो पुलिस से गया है, वो FIA के through, Interior के through FIA and then goes to Interpol. Their CNICs have been blocked. Nadra has blocked them.
एक चीज देखें. One thing we don't want to do. We don't want to. You do your investigation. Unless you're not doing your investigation, we'll intervene, or you're favoring someone.
My Lord,
so, but how you doing your investigation? ये आपका सवाल दीजिए. ये हम इसमें नहीं interfere करेंगे.
ये investigation आपके इस केस के take up होने के बाद हुई. अब
हो रही है ना बस.
अब शुरू हुआ है. अब काम शुरू.
अब if you want to have a meeting with the victim, apprise him what the progress of his case is. The concerned police officer can do so. I mean, after all, naturally the victim wants to know what you doing with his case. Who's his interest? It's not our interest. So I don't want to in any way jeopardize one way or the other the investigation by some remark in the Supreme Court, which is then tomorrow splashed on the media and completely wrecks up either your rights or his rights, or the person who's not before us, his rights or her rights. Investigation is your domain. If they complain that you are not doing it properly or something like that, then we can look into it as a general principle, not at specifics. I don't like going into specifics in these matters. Unless आप हमें persuade करें to go into specifics, that's a different thing.
ठीक है sir, we'll keep them informed and in the loop also.
Can they be informed of what's happened, or inform Mr. You are representing them now?
जी sir. Sir, मैंने report देखी थी. In Absar Alam's case, there has been some progress. In Matiullah's case, it has basically been an eyewash. And there is one, the request that I wanted to make, sir, is that there is one gentleman who clearly seems to have information about this, both crimes of Absar Alam's and Matiullah's, and he has reported his interview on that, on the subject. तो उनसे शाहिद मेतला साहब हैं, उनको कम से कम बुला के उन्होंने जो कहा,
आप बुला लें शाहिद मेतला को.
सर 2 दफा तो उसको नोटिस किया है 160 का. अब 160 का नोटिस, जैसे इन्होंने कहा है कि 160 का नोटिस का तो कुछ नहीं कर सकता है. वो एज ए विटनेस ही उनको इसी इंफॉर्मेशन के लिए किया था. अब उनका क्या करें ये बताएं फिर.
सर तो अब देखिए यही इशू आ जाता है ना, तो फिर आप उनको 155 का नोटिस नहीं. देखिए अब देखिए अब देखा आपने क्या हो गया. अब उनको बुलाएं कैसे? या तो आप पेश कर दो इनके सामने.
उन्होंने ये 2 लाइन का जवाब भेज दिया. उन्होंने 2 लाइन का जवाब भेज दिया. वो खुद तशरीफ नहीं लाए. 2 दफा 160 का नोटिस भेजा है. वो उन्होंने कहा कि मैंने एक इंटरव्यू कंडक्ट किया था, बस वो इंटरव्यू पब्लिक डोमेन में, एंड दैट्स अबाउट इट, एंड दैट नेवर मैटर.
सर वो इंटरव्यू अगर उसका
नहीं एक सेकंड, एंड आई हैव नो नॉलेज ऑफ इट. नाउ solve this also ना, how to get him. भाई आपने सही लिखा नहीं लिखा, वो एकदम से कोई कार्रवाई कर बैठे.
So he says, basically says that I don't know who has abducted him, and whatever I had to say was in an interview which is in public domain, and this is just a line and a half which he has sent us.
वो भी journalist है.
He's also a journalist, I believe.
हाँ?
Yes.
Yes. सर उन्होंने
जर्नलिस्ट वर्सेस जर्नलिस्ट हो जाएगा.
सर उन्होंने बेसिकली इंटरव्यू किया
भाई
था.
देखिए एक सॉरी टू से, या तो आपको इतनी क्रेडिबल है कि कोई हर्फ है आखिर है वो लिख दिया है. क्या क्या खबरें चलती हैं जो आप क्या बताएं. अभी आपको मैं कल की गलत खबरें बता दूं, कल की गलत खबरें चीफ जस्टिस के मुतालिक बता दूं आपको. बड़े सहाफ़ी बन गए, गलत खबरें. अब उनको मैं शर्मिंदा नहीं करना चाहता हूं, अगर आप पूछना चाहें बता भी देंगे क्या गलत खबरें चल रही थी. ठीक है, तो आपके हाँ जी उसका ये आ गया, बस मैंने ये कह दिया, बस खत्म. तो फिर ये इनसे राब्ता कैसे करें? आप ही के दोस्त हैं, आप ही के मेंबर हैं, पेश कर दें इनको. अब वो उनको 160 की नोटिस दें, वो मसला हो जाएगा, 155 की नहीं दे सकते, करें क्या ये? करें क्या, बता देना, सोल्यूशन भी बताइए ना सलाउद्दीन साहब। अब आप देख रहे हैं, इसलिए हम कहते हैं ना, जो ये चीजों को इंटरप्रेट करने में आपको हमें हर पहलू देखना होता है। अब मिटला साहब कल कहेंगे जी आपने मुझे अच्छा खूब फंसा दिया, मेरे खिलाफ FIR आ गई है।
ऐसा ना कर लिया तो मेरे साथ खड़े होंगे।
सर मेरी सजेशन ये थी कि अगर कोर्ट उनको बुला ले,
अब हम इन्वेस्टिगेटिंग ऑफिसर बन गए।
नहीं, he is more likely and he is more likely to take that seriously. And he may come and just say whether what he has stated in
हम अब उनका स्टेटमेंट रिकॉर्ड करेंगे।
नहीं, बिल्कुल नहीं सर, कोर्ट मगर जनाब के बुलाने से नोटिस भी
देखिए सलाउद्दीन साहब, you tell us, will we be acting in accordance with law? We'll do it. Tell me some provision where we could do it as a commission, but that's nothing to do with the police investigation. Police investigation, we have no powers. We can quash it, but we cannot investigate a matter.
It's not.
Yeah, nor are we acting as a commission of inquiry where we can summon, or under some other powers we are exercising. You get this. It cuts both ways. All these things you have to think very carefully. So that's why it's good that you are here to assist us on this. You tell us a provision, we'll use it. Abhi kar dete hain.
My lord,
don't say just do it.
184.3. There is no specific provision on that. But if your lordship
is part of your community, why is he not helping the police?
My lord, not everyone in the community is always on the same page. In no community, whether the bar or anywhere.
अब ये कैसे उनको बुलाएंगे?
My lord, with your permission.
नहीं, ये आपके वकील हैं सलाउद्दीन साहब, या तो सलाउद्दीन साहब को आप डिसएंगेज कर दें। यू सेड
नहीं सर, मैंने रिक्वेस्ट की है, उन्होंने आपकी परमिशन।
नो सलाउद्दीन साहब ने देखें, फिर वो
सर ये
we don't want to affect people's third party rights by some comment.
My right, sir. If I cannot speak for my rights, then nobody else has the right to do it, sir. मैं आपसे परमिशन सीख कर रहा हूँ सर। एक बात,
he is your counsel. We don't give you permission when a person is represented by counsel. As simple as that.
Sir, ये suo moto, I am the victim. If you don't want to hear me, I don't.
Don't put words in my mouth. Don't put words in my mouth.
So the thing is, suo moto.
Please don't argue.
Sir, वापस police
Mr. Salahuddin, this is not fair. Mr. Salahuddin, I'm calling you. Don't stand behind. Mr. Salahuddin, we are talking to you. Why are you not coming forward? Either you withdraw your wakalatnama. Who is stopping them? What are we doing? What are we sending these police reports for? ये तो बात नहीं कि वकील एकदम पीछे हट जाए, उसको करे आगे कर दो उसको। देखिए, ये हम आपको इज्जत करते हैं तो फिर आपको हम इज्जत देते हैं। हम आपको तो नहीं कहा कि आप इनकी वकालत करें, आप छोड़ दीजिए इनकी वकालत, इनको हम सुन लेते हैं। ये तो नहीं हो कि आधा सुनाओ फिर आधा सुनाओ। हम ये नहीं इस तरीके से चलेंगे। कोई प्राइवेट पार्टी है, करे यार वकालत, आपके कान में बता दे, आप मुझे बता दें। कुछ तो डिसिप्लिन हम रखें ना।
ठीक है,
आप बताएं what you want to do, we tell them now to do it. So far, who are we doing it for? Who are we doing it for?
Sir, to get to the truth, sir.
No, not to get to the truth. We are doing it for the victims. Mr. Qayyum Siddiqui, Mr. Toor, he went away. Matiullah Saab didn't want to sign it. Still we are saying we are interested. So why don't you sign it? Why don't you file a petition? No. So why aren't you doing it? I'm kidding. You can advocate on his behalf. Very well. Tell us what you want done, what sort of notice you want sent. We'll tell them if it's possible, they'll do it.
Sir,
if you want to have a private meeting with the office of the Attorney General, do so. वो भी हम कह देते हैं कि आप उनको, शायद आपको अभी शिक नहीं पता है, बाद में बता दीजिएगा, इसके तहत कर दीजिए।
जो इश्यूज वैसे इनकी इन्वेस्टिगेशन से हैं वो तो मैं नेक्स्ट डेट पे आपको इन डिटेल बताऊंगा। देयर आर मेनी इश्यूज, वकुए की भी, वीडियो रिकॉर्डिंग्स की भी, सीसीटीवीज की भी वगैरह, वो तो सब विल टेक सम टाइम। आई शो योर लॉर्डशिप्स द डिलिबरेट डिफेक्ट्स इन द इन्वेस्टिगेशन। ये वाला मैं सिर्फ इसलिए कह रहा था क्योंकि देयर इज अ जेंटलमैन हु सेज दैट I talked to such and such gentleman and he had...
We understood that.
Yes.
But that gentleman said, I'm not coming to you.
So then they should go to him. That is, in an ordinary police investigation, if a witness says, I don't come, so the police doesn't sit down and close the file.
कल वो बयान आ जाएगा जी, हमारे घर पे छापा, I mean, you know, देखें ये बातें कल आपके साथ ही होता, आप कहते हैं जी वो FI छापा मारने आए.
The most convenient, that's why the middle way that I was suggesting was that perhaps if the court could give him notice, I'm not saying that it's not a, you know, it's not a compulsion.
You don't understand, we are not the investigation officer. We can facilitate investigation, we cannot take over investigation.
It would, my lord, if your lordship was to ask him this even, it would facilitate the investigation.
Suppose
if
he says yes, it becomes 161 statement.
No, then your lordship would refer him to the police officer.
Refer क्या, वो कहेगा मैं नहीं जाता हूँ फिर. देखिए ये आप जब ये बातें होती है ना बड़े सोच समझ के, इसीलिए हम चाह रहे हैं कि एक तरफ आप जर्नलिस्ट की राइट्स हैं तो वो भी जर्नलिस्ट है. अब वो नहीं आना चाहता है, आप कह रहे हैं उसको आप पकड़ के ले आओ इधर, हम क्या करें उसको? आप 160 की नोटिस वही बात करेंगे जो आप कल वो आ जाएगा करने को.
ठीक है सर, we'll try and
help us to help
sir,
yourself.
We'll try and work on it on our level, and if not, then I'll make an appropriate application.
That's why you don't realize when you're setting precedents, the same precedent comes and bites you in a later case. You never thought of it that it would be applied this way, but it applies that way also. And since this is the last court, we are very careful of each order we pass, because there's no appeal, end of story, खत्म हो गया. आपके केस में खैर अब अपील हो गई है, मगर फिर भी बहुत मुश्किल होता है अपील करना. So ये जरा आप देख लें. But Mr. Attorney General, what we can say, if Mr. Salahuddin provides you a solution, please hear him.
No, absolutely, sir. There is बिल्कुल करेंगे. Police is absolutely interested in examining him, interviewing the witness, but there has to be a
Salahuddin
way to actually
things are changing. Things are changing. Please appreciate it. This is not the same office of the Attorney General. You've seen where Attorney General give him credit, where no cases he states it candidly. So
no, I always give him.
No, don't always do it. When he's in the wrong, contest him strongly. But where he is conceding, where he is giving you cooperation, then just because on what power am I issuing him thing? He's not committed contempt that I can call Mr. Metla here to issue a contempt notice. So I become the investigation, we rather will become an investigation officer. फिर कल को बयान होगा तो कहेंगे जी सुप्रीम कोर्ट में ये कहा था, तुमने यहाँ कहा था. हमारे सामने कोई बात करेगा उसकी वैल्यू नहीं होगी एज अ 161 स्टेटमेंट, या वो 164 रिकॉर्ड करे. यही दो तरीके होते हैं ना, और हमें तीसरा तरीका नहीं पता है. या वो कन्फेशनल वो यू कैन 164 में आ जाए या 161 में आ जाए. अब उसको समन कर सकते हैं या नहीं, वो तो अक्यूज नहीं है ना, उसने एक प्रोग्राम चला दिया, ठीक है. अब आप फिर कहेंगे जर्नलिस्ट फ्रीडम, वो आ जाएगा कल पिटिशन लेके, मेरी जर्नलिस्ट फ्रीडम को क्या हुआ, मैंने एक प्रोग्राम किया, आपने मुझे बुला लिया अपने केस में. तो देखिए ये चीजें आप लोग को, इसीलिए हम कह रहे हैं, पर हमें सोच फूक के पैर रखना है. आपके कोई मसला है उसको हम आज हल करते हैं. That's why they're not arresting. We are recording your statement. You're not arresting anybody.
Absolutely, man.
ठीक है, चलें. ये लिखा हुआ है पहले या नहीं लिखा हुआ है?
ये पहले लिखा हुआ था, मगर उसके बाद एक बंदे को तो अरेस्ट किया था फिर भी.
नहीं, हमने लिखा हुआ. कौन सा ऑर्डर था बताएं?
The order was the statement was.
नहीं, ऑर्डर बताइए.
जी सर, डेट थी उसकी.
नहीं, कौन सा ऑर्डर है?
जी मैं बता रहा हूँ सर.
Usually the Attorney General doesn't violate court orders.
Sir, it was 29th January.
What happened?
Oh, no criminal. It's page 3 of that order. Learned Attorney General states that honest criticism of a judgment or an order is not a crime and no coercive action will be
taken. Where are you reading paragraph?
No, sir, ye type page 3 of that order, top paragraph. Third line. Learned Attorney General states that honest criticism of a judgment or an order is not a crime and no coercive action will be taken, no criminal case registered in this regard, and extends an undertaking on behalf of the federal government. After this, the FIR and arrest.
No, criticism of a judgment तो बताएं उस किसी को arrest case basis पे तो हम इनको contempt notice देते हैं.
Then the undertaking should be for the what I have challenged here, the inquiry, the subject matter.
Now in the inquiries we can pass an order. Agar aisa, I'm not aware that we had passed such an order, but if we had, just remind me.
No, my lord, and just to take this further, The undertaking still stands. The FIR registered against Mr. Asad Tur, the contents of the FIR, and when I had stated before your lordship that the contents of the FIR do not make out an offence which was charged, for which he was charged, and that was the end of the matter there. Criticism of an honest criticism of the judgment is not something for which anybody has been charged after this undertaking has been given. There's no instance.
No. They want assurance that the notices that you have issued, no one will be arrested till the next day.
No one will be arrested. That.
चलो हम ये लिख देते हैं.
Yes.
इसमें लिखिए. Mr. Salahuddin Ahmed, learned Mr. Salahuddin Ahmed continues his submissions. It is now 2:25 p.m. and as suggested by him, adjourned to Tuesday, 2nd April 2024. Full stop. Learned Council submits that number of notices were issued by FIA under section 160 of the Criminal Procedure Code 1898 to journalists, and he apprehends that they may be arrested. Full stop. Learned Attorney General undertakes on behalf of FIA that no journalist will be arrested to whom a notice under section 160 was issued by FIA.
My lord. Yes.
Salahuddin Ahmed, you can smile.
It's been a long day, sir.
Chale, on Tuesday, inshallah.
Your Lordship, एक दरखास्त मेरी प्लीज सुन लीजिए.
सर ये CP27 में ये पाकिस्तान मीडिया डेवलपमेंट अथॉरिटी के ऑर्डिनेंस का बिल भी आ गया, तो आई विल नॉट बी प्रेसिंग दिस.
मुझे पता था आपने प्रेस नहीं करना है.
सर वो चेंजेस काफी आगे से टीवी पे भी आपने
नहीं अभी आप इंस्ट्रक्शंस किससे ले रहे हैं? आप किससे इंस्ट्रक्शंस ले रहे हैं? नॉट टू प्रेस.
अच्छा सॉरी, आपकी किताब.
नहीं आई नो दैट, बट एवार ने तो हमारे सामने कोई विड्रॉल की पिटिशन नहीं फाइल की है, दरखास्त एक डाल दीजिए, नेक्स्ट डेट को हम कर देंगे ऑर्डर उस पर. कल आपके खिलाफ कोई आ जाएगा कि जी उनको मैंने इजाजत